Welcome to the special FISA Foreign Intelligence War on Terror issue of Blogging Heads TV. We're new here, so we'll start off with some introductions. Marty, why don't you start off?
I'm Marty Lederman. I blog at Balkinization, that's balkan.blogspot.com, and at SCOTUS blog, and occasionally on the Georgetown University Law Center blog.
And I'm Orin Kerr. I'm a law professor at George Washington University, and I blog at the Volokh Conspiracy, Volokh.com.
Orin, we should tell them that we have one other thing in common besides that we both teach constitutional law, and that is that we actually worked together, or at the same time, at the Department of Justice back in the old days, in the 1990s and late 90s and early 21st century.
That's absolutely true. In fact, I remember once writing a memo on how the Fourth Amendment applies to computers, and I was told, no, Marty Lederman has rejected that. And right then I knew someday I would want to debate Marty Lederman on Blogging Heads.
I don't recall that, and since then, of course, you've gone on to fame and fortune as a Fourth Amendment expert, and I have almost no working knowledge of the doctrine.
All the better. All the better.
All the better.
So today we wanted to talk about the new statute that Congress passed, the Protect America Act, and who doesn't want to protect America? The new statute that modifies the Foreign Intelligence Surveillance Act. We're also going to cover an upcoming Supreme Court case, the Medellin case, an exciting French name for an interesting case on the Guantanamo Bay detainees.
An Algerian name, actually.
Is it Algerian?
He's Algerian and a Bosnian citizen, yes.
Well, clearly you're taking the lead on that discussion, Marty. So we're going to talk about surveillance. We're going to talk about detention, all sorts of issues in the news today about the war on terror and the legal response. Marty, why don't you start off with some background on foreign intelligence surveillance law?
Okay, this is the quasi-lecture part of the episode. We'll try to do it very briefly just to give you some historical context of where this statute came from. In general, in the criminal law system, not uniformly, but in general, in order for the government to engage in surveillance, to intercept one's communications, telephone or email communications, they have to demonstrate probable cause that some criminal activity will be revealed by the surveillance. And go to a court for a warrant to that effect. Now, for many decades after the Second World War, side by side with law enforcement engaging in forms of surveillance under these Fourth Amendment rules, the intelligence agencies were engaged in warrantless surveillance, not for criminal law enforcement purposes, but in order to discover actionable intelligence about either domestic or international problems that the intelligence agencies wished to address. And they were doing this wholly outside the context of either the Fourth Amendment or any statutory regime. And in the mid-1970s, the Church Committee in the United States Senate had hearings in which they uncovered all sorts of abuses that had occurred within the intelligence agencies generally. And one set of those abuses were revealed to be the national security agencies' programs that were called Operation Minaret and Operation Shamrock. In both of these programs, the NSA, which is the largest and most sophisticated intelligence agency in the United States, the one that does signals intelligence, has massive computers to collect all sorts of information from wire, radio, and other sources and interpret them. Both of these projects started as attempts by the NSA to get intelligence on international targets, on people overseas for foreign relations purposes relevant to the executive branch's foreign relations and intelligence and national security objectives. Over time, however, these international interceptions that the NSA engaged in understandably picked up a lot of information about U.S. persons here in the United States, particularly when the intercepts were of communications between people overseas and in the United States. And the NSA developed these dossiers on many United States persons, and the Senate and the Congress as a whole was fairly shocked by this and decided to do something about it. And over the course of about 3 years, between 1975 and 1978, Congress engaged in widespread hearings, investigations, and negotiations between the legislature and the executive branch on the creation of the Foreign Intelligence Surveillance Act of 1978, FISA, as its acronym is. It's known by its acronym, FISA.
Not FISA, in case you're
Not
following
FISA. Not FISA. But FISA, FISA was developed basically in the opposite manner of the way that last week's legislation was developed. Last week's legislation was created sort of in the middle of the night, in the dark, without hearings, without any legislative history, and without any public investigation or oversight or anything like that. FISA was the opposite. It was 3 years of give and take and back and forth.
Although, Marty, I think the question is whether the new statute fits within the old statute and is kind of consistent with it, which is a separate question of how it was passed.
That's right. That's right. We'll talk a little bit about process and about politics, but mostly what you and I know more about is the substance of FISA and the Protect America Act of 2007, and that's what we'll discuss. So the basic rule under FISA for almost going on 30 years is that in order to engage in any form of electronic surveillance, a governmental agency must demonstrate to the FISA court probable cause that the person being targeted, a domestic person being targeted, is an agent of a foreign power, which could just mean a government official or a terrorist, but an agent of a foreign power. Now, FISA originally did not cover certain sorts of surveillance that the NSA engaged in, completely outside the statute, namely radio surveillance or satellite surveillance of communications of persons overseas. And so FISA never covered in the first instance the NSA's satellite surveillance of international communications, or for that matter of any wire communications if they were picked up overseas. So if the NSA were targeting someone in Pakistan and the interception was being done either by satellite or in Pakistan, that was not...
Marty, let me simplify this a little bit, though. Isn't the basic rule under the 1978 statute that the statute only applies to surveillance from inside the United States, first of all, and it's only targeting people that are inside the United States? So there's some rules limiting surveillance outside the United States of people inside the United States, but what the statute was really trying to do was say, if the government is going to monitor somebody for terrorism-related reasons, they think they're a spy, they think they're a terrorist, and they're inside the United States, the government needs to get a special warrant under this FISA court. That was what the 1978 statute was trying to do.
That's correct.
And then the question is, what does the new statute do that's different from that? And to my mind, it's really just really a clarification of if the government is watching somebody outside the United States, they think that person is outside the United States. They have reason to believe that person's outside the United States. A tricky question, where is somebody, when you're talking about internet surveillance, say, or even telephones where you don't know if the number and the place are linked. The government can watch that person outside the United States, and it's covered under the same rules that surveillance would be covered under the traditional FISA regime if somebody was known to be outside the United States. People in Pakistan, for example, something like that. And that there's what the new statute is really focused on is surveillance of people outside the United States. And why is it needed? Well, because of this technological reason. It turns out a lot of communications that go foreign-to-foreign communications today go through the U.S., go through these U.S. switches in New York, other places inside the U.S. And the question comes up, well, what are the rules that regulate foreign-to-foreign surveillance people outside the U.S., but from a switch inside the U.S.? And that's kind of the reason why we have this new statute. That's well,
okay. I guess I'll differ with you there. It's the reason why we have a new statute. But on that point, let's distinguish two types of conversations or communications here. Communications between one person overseas and another person overseas. Everyone agrees. Everyone in Congress, everyone in the privacy community, everyone agrees that the NSA should be able to collect that intelligence on those sorts of communications without going to the FISA court, without making a showing.
Okay, so if there's somebody in Pakistan who the government thinks is involved with Al-Qaeda,
right,
and that person makes 1,000 phone calls a month, and 99% of them are within Pakistan, and let's say there were 2 calls a month to somebody believed to be inside the United States, should a warrant be required for that? To monitor that person in Pakistan?
Well, let's just clarify. So everyone agrees, right, that as to the communications that are between one person overseas and another, the FISA court requirement should not be there. And the Democratic bill would have done just that.
Okay.
Right? The bill that the Democratic Party put forward and that the House voted on would have covered that. It would have excluded that from FISA. Now, why wasn't that excluded to begin with under FISA? Because of something of a technicality in FISA, right? FISA said that if a communication is intercepted here in the United States, even if it's intercepted here in the United States, and you don't know whether one party or the other is located here in the United States, you have to go to the FISA court and get a warrant for that.
Right. And let me just step back here for a minute, because there are a bunch of different variables that are out here.
Right.
We've got where the monitoring is occurring,
right,
where one party is, where the other party is, if known, they may or may not be known, and then also the purpose of the surveillance. So you can sort of set up a very complex matrix and say, all right, one person known to be in this country, another person unknown, monitoring occurring inside the U.S., monitoring occurring outside the U.S. And what the new statute does is say, listen, if there's surveillance directed at somebody outside the United States, that's not a FISA problem. That's not something for a warrant. The warrant requirement is triggered when the NSA or whatever the agency is says, hey, now we're interested in somebody inside the U.S. We want to watch somebody in California instead of somebody in Pakistan. Now we need to get a warrant. And that's the line drawn by the new statute.
Well, we'll talk about
amending
that,
the statute.
I don't think it's quite that clear that if the NSA or other intelligence agencies are interested in someone in the United States, that they, under this new statute, that they have to get a warrant. But we'll get to that in a minute. We're in agreement, right, that everyone agrees that there's no problem with warrantless, other than rare cases where Americans are overseas. There's no problem with warrantless surveillance of communications between one person overseas and another.
Yeah, well, I'd say there's a broad consensus among policymakers. Clearly, a lot of people don't agree, right? You can't get everyone to agree on anything in surveillance.
But in Congress, there was no dispute about that,
right.
And that's not what caused the furor, because the Democrats were willing to go that far, and you and I would have absolutely no problem with the regime.
What this whole dispute is about is what to do when the government is monitoring somebody outside the U.S. who has his 2% of communications with somebody inside the U.S.
Or 100%.
Or 100%, although when would that come up?
Here's the fear. Let's talk a little bit about this statute then. What changed between 1978 and today? You're absolutely right that in 1978 the NSA did not need to get a warrant to engage in satellite communications or communications of persons in Pakistan, even when they called the United States. Now, that's in part only because Congress decided to put that off for another day. Congress actually thought that was problematic, and they would get around to dealing with it later, according to the House and Senate reports.
Well, Congress is a they, not an it. I mean, some people want to do that.
Many people in Congress...
They might have slipped some language into some reports, but I'm sure a lot of people disagree.
Correct. The reports reflect that this was a problem. The problem of foreign intercepts that pick up domestic persons was a problem Congress would get around to later, and they never did. But instead, what changed, as you pointed out, was the technology. And two things changed dramatically between 1978 and today. The first is that it's become much easier for the NSA to collect, to surveil, to intercept communications between people overseas and other people overseas, and between people overseas and in the United States.
How do you figure?
Well, in part because the communications are being routed through wires here in the United States.
But I don't know if that means surveillance is easier or harder. It means that there's a change, right? So for example, people shift from traditional telephone calls to encrypted online communications. suddenly becomes much harder. Now, nobody announces that. Nobody comes up with a press release saying, government powers were cut in thirds today or something. You don't get that. But I think my sense. I mean, obviously, a problem throughout this entire discussion we're going to have, and we've always had, is we don't know the exact practices that are going on the inside,
and we don't know quite what the legislation does.
We don't know how the Justice Department is interpreting some of this language, or how the FISA judges are interpreting it. I mean, we're all on the outside trying to peer in, guessing at what the practices really are, and then trying to judge it as a matter of policy. So
let me pause there, because as you know, to me, this process problem and the obscurity of the statute is, to my mind, one of the most important problems with it. We joked before we started filming. My view was that there's probably no more than 40 or 50 people in the United States who have a firm idea of what exactly this legislation authorizes, and at least 99% of those people are employed by the executive branch. You weren't quite so negative in your assessment of that.
We don't know what we don't know, right? So that
right, but we haven't been able to figure it out, right? For sure. I mean, we have some idea of what we think it might allow. I think the language of the statute is incredibly broad. But
let's step back.
Let me just mention the one other change between 1978 and today. So why wasn't this much of a problem in 1978? Why didn't people care that the NSA could intercept foreign to domestic communications in 1978? One reason was that the NSA it was a little bit difficult for them to do so. But the principal reason was there weren't very many communications between individuals in the United States and people overseas, right? Remember, it was mostly phone calls, and they were very expensive. I was a teenager in 1978, and I wasn't making a lot of international communications. Whereas today, we freely talk on the phone and send emails overseas.
But I wonder if you're not focusing in the wrong place. I mean, you're focused on the possibility that this is your concern, if I understand you correctly. You're worried that the government might be able to use this statute, this amendment to the 1978 Act, to start watching people inside the U.S. under the guise of watching people outside the U.S.
Not even so much that. Let me put it a little bit differently. One thing is, yes, I am fearful that will happen. That's exactly what did happen in the decades leading up to FISA. That's what happened with Minaret and Shamrock. They began as programs that were ostensibly directed at surveillance of people overseas, and over time, the agencies developed enormous dossiers of the information that was gleaned about people here in the United States.
Although that was a period before the FISA statute. And the question is whether this small, to my mind, fairly small, discrete change to the statute really sort of takes us back to the 50s and basically scratches the entire statute. I don't think it does. I think it's actually a pretty narrow fix.
That's my first concern, is that just human beings and government agencies being what they are, that over time the temptation will become great where there is virtually no oversight.
Tell me where in the statute you think the statute lets the government do that.
Well, let me get to my second concern, which is that even the well-motivated agency, looking at this statutory language, would be, even if it's not pretextual, they would be able to, in fact, develop vast databases of information about communications that you and I and every other American engage in every day, wholly consistent with this statute. So let's turn to the language, and it's a single sentence that really does most of the work here. Section 105, capital A, which says that it takes a certain category of surveillance and puts it outside of FISA, so that you don't need to go to the court to get a warrant before you do it. And here's how it's defined. Surveillance directed at a person reasonably believed to be located outside the United States. Okay? So if any surveillance is directed at persons reasonably believed to be located outside the United States, it's free game for the NSA. Not
totally free game.
Not totally free, but
not something they need individualized warrants to obtain.
Correct. Right. So, in my view, what this basically allows is for the NSA to intercept off of wires in the United States and elsewhere virtually all international communications and start a database of them, either under the pretext or under the sincere claim that what their surveillance is directed at is the foreign terminal and not the domestic terminal. There's nothing to stop the NSA. Almost nothing. We'll just talk about the minimization.
Let's talk about the limitation on that, though. The minimization. Okay. Well, there are a couple things going on. One is how realistic is that as a problem? I mean, my understanding is that the real issue here is the government is watching somebody in Iraq, and that person is making 1,000 phone calls a month, and there are all sorts of calls in all sorts of places. Does the government need to get a warrant to monitor the person who's out, a specific target? The government is watching some specific person, and because they think he's involved in terrorism, and they want to monitor that person. Do they need to get a warrant because there's a chance that person might talk to somebody in the U.S.?
Well, I'm going to agree with you on this one. The answer to that is no. Okay. You should not need a warrant
what's wrong
merely because of the possibility that someone might engage in conversations with those here in the U.S. The trick is, what are you going to do? What should Congress do, and or what does the Fourth Amendment require Congress to do to deal with the subset of communications that do involve people here in the United States?
And the answer of this statute is to have a program that minimizes the information obtained that's to anybody in the U.S., which filters out all the foreign intelligence information, puts that away, and then uses the foreign intelligence information that's collected, if any, to obtain a FISA warrant on the person inside the U.S. And it seems to me that's a pretty good answer. That's not a bad solution.
So what this means is the NSA can freely intercept all foreign to foreign and foreign to domestic communications. Say quite sincerely that it's directed at people overseas. And whenever those communications uncover anything related to, the phrase is, foreign intelligence information about people in the United States, they can then use that as justification for starting to direct their surveillance at the people in the United States. But even short of that, they can create dossiers. They can collect the information they get from these foreign to international calls to collect information about our communications with people overseas. As long as they are related to foreign intelligence information.
That's a big if. That's like if you just happen to be talking about secret terrorist plans, the government can monitor you. Everybody who's talking about terrorist plans gets monitored. I mean, hopefully that's a small group of people, right?
Agreed. And if the statute were somehow limited to the government only being able to obtain, to maintain, to hold on to those communications that actually reveal terrorist activity of U.S. persons, it would be quite a different statute. In fact, it would be fairly close to the statute that the Democrats proposed. But it is far broader than that. I
don't think it's actually that much broad. Let's step back for a minute here. I mean, I think what we have is you and I more or less agree on what powers the government should have. In fact, I think there's actually a fairly wide consensus as to what the powers are that the government should have. That's actually really common in surveillance law. There's a lot of sort of people who identify as pro-government or identify as civil libertarian in the abstract. And when you start talking about very particular rules, should the government be able to monitor this person? Usually there's a pretty broad consensus. Not everybody, but a pretty broad consensus. And what we're talking about is taking that consensus that the Marty-Orin combination have, and let's assume it's broader than just the two of us, and turning that into statutory language. And I think this statute does that reasonably well, subject to the problem that it's all being a lot of the real work. What's the technical capacity that's being used? What are the protocols that are being used to figure out who's inside the United States, who's outside the United States? That all comes into something that's certified before the FISA court, that the judges review under a deferential standard, but nonetheless they review. And so we don't see that, so we don't know the details of what's happening. But at least based on what we know, it seems to me that this is not a bad solution. And everything you read online about the new statute is critical, right? Everybody hates it. Everybody despises it. But
not at Volokh, not at the Volokh.
Not at a reasonable blog like the Volokh conspiracy.
Right.
But I think a lot of people are paying attention to the lead up to the statute. A lot of people are paying attention to who won, who lost. Is Alberto Gonzalez happy? Well, if he's happy, everybody then has to be annoyed with the new legislation. Jack Balkin had a post on your blog right after the new legislation. What were the terms that he used? The craven Democrats who gave up, folded over, turned around. I mean, it seemed to me that kind of comment completely ignores the fact that the Democratic leadership is dealing with a specific problem, a specific threat, and a specific statute, not a symbol as to who wins or who loses. And when you actually look at the language and you look at what was done, we don't know exactly how it's going to work. We always have that problem in all surveillance contexts. But this seems actually not bad.
But, Orin, that's the problem. We don't know how this is going to work, and there's no real oversight.
Well,
Certainly
there's much more oversight. I mean, there's a lot of oversight relative to what seems to have happened under the terrorist surveillance program, right? Which would have been no oversight at all.
Correct, but let me back up one step and say the way in which this is much broader. Let's introduce the terrorist surveillance program for those viewers who don't know it by that name. This is the program that the Bush administration began in the fall or winter of 2001, in which it circumvented FISA. It just took it upon itself unilaterally to engage in surveillance of foreign communications. Well, at first, probably not only foreign communications, but as of the spring of 2004, 2004. As of the spring of 2004 up until January of 2007, the administration was engaged in a program outside of FISA's terms that I think we've both blogged that it was an illegal program.
The legal rationales put forward were, in fact, poor.
The legal rationales were poor. That's very generous of you, Orin. Yes. On that we agree. Is
giggly a better word?
What's that?
Giggly.
Jiggly?
Giggly.
Giggly?
Oh, as in it makes you giggle. Okay, never mind.
I wasn't laughing.
Okay.
Widespread felonious activity by the executive branch in secret without any oversight. I didn't find it terribly funny. I found it obviously. Go read my blog. I didn't have much of a sense of humor about it, but
you used a lot of exclamation points.
A lot of exclamation points. But to your credit, Orin, Orin was among those with the best blogging critique of this program as well. This program, as limited in 2004 after the famous Comey, Goldsmith, Ashcroft, Mueller, Bush, Cheney, Addington hospital, crisis, was in theory limited to conversations in which at least one party was overseas and at least one party was an agent of Al-Qaeda or of an associated terrorist organization. Now, just so everyone understands this new bill is by no means limited to terrorism. Okay, it does have the common feature of requiring that at least one party be overseas, and that in fact the surveillance be directed at the overseas party or person reasonably believed to be overseas. But it could be anyone overseas. It could be my cousin in Scotland. It could be your mother-in-law in Italy, or
no, I don't have a mother-in-law in Italy.
That won't stop them.
Damn it, they're good.
They're very good.
No, but I think it's helpful to point out, though, that the NSA has long had this power, just not from U.S. switches, right? The traditional FISA statute has basically said, listen, if you're doing monitoring from outside the U.S. of somebody outside the U.S., monitor away, subject to Fourth Amendment limitations for basically U.S. citizens, some people with strong U.S. ties that happen to be outside the U.S.
Well,
so if you travel to Italy to visit your non-existent mother-in-law, then you're still protected by the Fourth Amendment, just not under the statutory protections. You're now just covered by Fourth Amendment protections.
Well, I agree. There were no statutory protections, not because Congress made a concerted decision that there should not be any protections for this. In fact, they the House and Senate reports, said that it was something that they should take up later.
Marty, this House and Senate report seems to have a very strong pull on your thinking here. I'm a little worried.
I'm old-fashioned, Orin. I believe in legislative history.
Ooh,
right?
Ooh.
Yeah, it's very...
I'll forgive you, don't worry.
Okay, thanks.
You don't know the staffer that put in that language, do you?
What's that?
You don't know the staffer that put in the language, do you?
I don't know this. I probably do, but we don't know which staffer it was or which OLC attorney it was.
There you
go. But we probably know that person if they are still alive. In any event, as I was saying, two things have changed dramatically. You're right that as a legal matter, the NSA could, without any outside the statute, collect this information from sources overseas, beginning in 1978. But there weren't so many communications in 1978, and it was, in some respects, more difficult for the NSA to collect that information.
So,
now
Marty, let's go back, though, to the question of what you would want the government to do.
Okay.
So the government is watching some suspects they think are involved with Al-Qaeda.
Or just every person who lives overseas.
The government is watching somebody in Pakistan. They have a target. They're targeting somebody in Pakistan, who every month makes about 1,000 phone calls,
right.
And every month 2 or 3 of them are to somewhere in the U.S.
Right.
What legal authority would you like to see to regulate that kind of surveillance? No warrant at all? A warrant? What kind of warrant? What do you think the answer should be?
I mean, I actually think that's something of a hard question, but let me give you...
Well, no, wait, Marty, you can't just say it's a hard question, because that's why the statute's here.
I'm going to offer you a minimalist view of it, okay? A baseline requirement, okay? And I'm going to make an analogy to something in FISA, right? This isn't the first time Congress has dealt with this sort of an issue. In 1978, if the general basic FISA rules had been all that had been put in place, this would have created a problem for U.S. intelligence with respect to another form of foreign intelligence, namely the ability to wiretap and surveil foreign embassies and consulates here in the United States. Okay? And so Congress needed to deal with that. They didn't want to prevent our intelligence agencies from putting wiretaps on foreign embassies and consulates,
right?
But the
for which I assume they needed a FISA order, right? That was what FISA was. They would have
needed a FISA order, but in order to get around that problem, Congress enacted Section 1802, Title 50 of the U.S. Code, Section 1802, which is different from this new statute in at least two very important respects. The first is it says you're going to be outside of FISA and not need a warrant if your surveillance is solely directed, not just directed at, but solely directed at the acquisition of contents used on property or premises under the control of a foreign power. Okay? So if it were solely directed at a foreign entity, or in this case a location, you were outside of FISA. And so I query
I'm going to go back to my question. What rule would you have to govern
rule number one is I would add,
in Pakistan?
Right. Rule number one is I would add the adverb solely here, right?
Add the adverb to what?
To the new statute, which allows you to be outside of FISA, have warrantless surveillance for any surveillance directed at a person reasonably believed to be located outside the United States.
What is it? Yeah.
At a very minimum, I would say solely directed at.
What does that add?
Well, it means that the surveillance that surveillance that is directed both at someone overseas and at U.S. persons.
Okay. Well, now we're getting back to the question of what
would not be exempted from FISA.
But that seems to me is an objection entirely based on your view of what the language directed at means.
Right.
And I think on that, I think the directed at language seems to me to be about the traditional intelligence community notion of a target. Who are they trying to get information on? Whose line are they tapping?
You're also assuming that any particular surveillance could only have one target. What I'm suggesting is the surveillance might have, if they suspect an American as being somehow related to either a terrorist cell or, frankly, to just a business interest overseas or anyone else they're interested in overseas. Maybe they would surveil, from both ends, both the foreign end and the domestic end, and say that it's directed at both the foreign and the domestic person.
Well, if it's directed at the domestic person, then they'd need a FISA order.
It does not say that. I mean, I wish the statute did say that. Maybe we can create some legislative history right here.
I think your interpretation just does not. First, your interpretation does not make intuitive sense. Second, it's contrary to what the administration is saying. Third, it's contrary to the traditional notions of what a target of electronic surveillance is.
But
it just seems to me that your view of what the statute is doing is based on this fear you have that the phrase that says one thing really means another.
Correct.
And maybe they're using it in some secret way to using a little clarification to circumvent the entire statute. And,
Correct.
Why do you think that? Other than just paranoia, fear, concern. What's your basis?
They could have drafted this provision to track Section 1802 of FISA. It could have said solely directed at someone.
Yeah, you know what the problem with solely directed at is that whenever you have a two-way communication,
right.
What does it mean to direct your communication solely at the person outside the United States? Does that mean if we're talking and I'm outside the U.S. that they can only get my words and not your words?
Well, we'll get to that in a second, but that leads to the second difference between this and the foreign embassy provision of FISA. The second difference is that in order to under FISA, to surveil a foreign embassy here in the United States, according to the statute, you get out of FISA, there has to be no substantial likelihood that the surveillance will acquire the contents of any communication to which the United States person is a party.
Right.
Okay? So it has to be both solely directed at the person overseas and have no substantial likelihood that it will acquire the contents of any communication.
Which would mean you couldn't monitor anyone outside the U.S. unless it was really clear they were going to have zero contacts in the U.S. Right?
No, it means that you have to set up a system, a statutory system, or an administrative system, by which when your intercepts land on a person here in the United States, you have to stop right there, not acquire that information or not hold on to that information.
Right.
Unless you can demonstrate that the person in the U.S. is an agent of a foreign power.
Okay, good. Now I think we're getting to a direct disagreement where I side with the administration's view on this one. I think they're absolutely right. Which is if they're monitoring somebody outside the U.S.
Right.
And that person is talking about random things, the weather, nothing related to any intelligence value. They shouldn't be allowed to listen to it. They should have to minimize it, just like they do in a traditional wiretap. But if that person is actually talking... Hold on, wait. If that person's actually talking about terrorism, hey, are you going to blow up something tomorrow? Yes, I am. I want them to collect that, and I want them to then use that to get a FISA order to watch the person inside the U.S. I don't want them to say, oh, we're watching this spy in Pakistan, or this Al-Qaeda agent in Pakistan, who keeps talking to people in the U.S. Too bad we can't listen to that conversation to find out if it's innocent or not. I want them to know if it's innocent or not. And I want them to get an order if it's not innocent, and for them to minimize it if it is innocent. And that's what the new statute does. And that seems to be a pretty good answer.
But even if I agreed with you that was the proper regime, the statute doesn't do that at all. The conversation doesn't have to be about terrorism or any urgent...
foreign intelligence information.
Right. Foreign intelligence information, which is defined as any information related to the conduct of the foreign affairs of the United States or the national defense or security of the United States. Now, that's a very, very broad... First of all, there's no check on that. That's just the standard. There would be no judicial review of that. But even so, that's an incredibly broad... What's not within the conduct of the foreign affairs of the United States?
There's judicial... Wait a minute, though. There's judicial review of the protocol for minimizing... Correct. Which communications count as foreign intelligence information and which ones don't.
Right.
Those categories are understood as being either information relating to terrorism, that's the first part of the definition, or information about foreign governments and relating to the national defense of the U.S., which is basically, other military secrets, basically. If there's a Soviet agent, to go back to the 1970s, who has information on the Soviet military capacity, they can intercept that piece of information. Because the original statute was really dealing with terrorists and spies, or terrorist foreign government agents. Those are sort of two different entities. And, of course, now we're all really focused on the terrorist side of it. And I think that foreign intelligence definition, I mean, could you try to construe it really broadly? I guess, but try getting that past the FISA.
Well, okay, well, I mean, why is do you disagree that the FISA statute as it currently exists with respect to foreign embassies, if there's even a chance that you'll pick up a domestic person, you have to cut off you have to go to the FISA court? Show that.
Yeah, I do think this is just a different scenario.
It's much broader, right? It's related to anyone overseas and all of their communications, including those with people in the United States, which is going to be a much vaster category of communications than those that we have with foreign agents, foreign embassies and consulates.
So just so I understand, what you would want the rule to be is that if the government is watching this person in Pakistan that they expect is an Al-Qaeda agent, and the Al-Qaeda agent calls a phone number in Washington, D.C., you would want them to not listen to that call. You would want them to say, whoa, that's somebody in the U.S., now you're violating the rights of somebody in the U.S., don't listen in on that call. That's your preferred rule.
That's basically...
Wait,
tell me,
do you like that rule or do you not like that rule?
No, not don't listen in, but go to the FISA court and demonstrate that at least the foreign target is an agent of a foreign power or a terrorist. At the very least. Right? There doesn't have to be any such showing here. That's the FISA regime. The FISA regime is you have to go and show that the target, each of the targets, right? So, is someone who's either an agent of a foreign power, which has been recently amended to include people engaged in terrorist activity.
Right.
So yes, when you hit an international to domestic call, I think you should need to make some sort of showing. It's not an incredibly onerous showing to the FISA court.
I don't know how much. I mean, say the paperwork is 50 pages, and then you submit it to the judge, and the judge gets back to you.
Well, the alternative is that they can just not freely collect. You're right, because there is a minimum. We should tell our viewers there is a requirement. It's not clear whether it's a requirement, but there's a possible requirement in the statute, and it's another ambiguity, that the administration, that the NSA has to come up with a system of minimizing so that when it does pick up communications that are foreign to domestic, the only ones that they can maintain, that they can keep, are those related to foreign intelligence information, as I've broadly defined it, as you've
Marty,
more narrowly defined it.
Let me jump back, though, because so the government's watching this guy in Pakistan, and they don't have a FISA warrant because they don't need a FISA warrant. He's making international calls.
Right.
Suddenly they see him calling the U.S.
Right.
So I gather you would want them to get an emergency FISA order, right? If they have the probable cause. They need to figure out, first, do they have probable cause in every case? So this person calls the U.S. once a month, and every time they do so, they need to figure out, do they have probable cause? Let's go to the FISA court, and let's write up our 50 pages really, really fast, get it to the judge, and then hope that call is like a really long phone call.
Orin, here's where your technical and computer expertise is going to be a real advantage over mine. I mean, it's possible one could, if you're collecting, a vast reservoir of calls by persons overseas, and the computer shows that X percentage of those calls are domestic, that there will be a database of those calls that the agency gets to hold on to, but they can't have humans rifling through it or creating dossiers based on it unless and until they go to the FISA court. They're not going to lose the information necessarily.
Yeah, well, I would imagine they are.
I don't know that they would have to necessarily cut off the foreign wiretap just because the guy makes one phone call a month to the United States.
Well, no, but I think that's what
you shouldn't
they have to do, actually, because you're assuming that the NSA records everything in the world, and then the question is, when do they get a court order to go back and listen to it? And I think if the NSA doesn't have the authority to do this in the first place. They can't have their secret little room, be very quiet, at AT&T in which they collect the information. Now, if you want a rule that says
why not? Why
the
not?
NSA can collect everything in the world with no limitations, they just can't listen in except pursuant to different rules, and that's we can talk about
not everything in the world. They can actually pick up. They can perhaps. I mean, I haven't thought this through, but perhaps the rule would be something like, yes, the computers can pick up vast reservoirs of foreign communications, and when you recognize that one of them is with a person here in the United States, before the agency gets to either retain or listen to or read that communication, they have to make a certain showing to a court. That's been the traditional view. That doesn't strike me as so preposterous.
Well, wait. You're assuming that the NSA records everything in the world and then just goes back. Why do you think that?
Well, if they don't record it, then there would be no problem, right? If they're not maintaining it, I forget what the verbs are of the statute. Maintain. I don't have it right in front of me. Maintain, preserve, and I forget what the verbs are. But right, if it's merely going through a computer and no one's ever reading it, one can imagine drafting a statute to say that's okay because it's not much of an intrusion on.
Right, but I think the
privacy if no other human is ever going to see what our phone calls and emails.
Marty, I think you're embracing a Big Brother that would.
I'm embracing Big Brother?
Yeah, you're saying that government should be allowed to collect absolutely every piece of information in the world, subject only to some limitations on when they can screen through all the data they have. And I think this is a question about what information can they collect.
No, I'm saying every communication of persons overseas, which is what this bill does allow them to do without that qualifier.
But in order to be able to go back and get the monitoring information of people inside the U.S., in effect get a prospective wiretap, all the communications that they recorded, they'd have to collect everything, right?
I don't know what they're collecting or what their capabilities are.
Well, that's an important caveat because it seems my understanding is what this is about is just the ability to collect that information. Can they monitor that information? I don't know of. We don't know the full capacity. Clearly, they're collecting a lot of stuff overseas, right, through Echelon or whatever. Sucking all the stuff out of the sky, and you read Bamford's book and all that kind of stuff.
Skies, tubes, wires, right?
Whatever they are, tubes, exactly. But my understanding is it's a very different situation when you're dealing with information from U.S. switches. And the question is, should the government have access to those materials, and in what situation? I don't think you can just say, well, once they know it's to somebody in the U.S., then they can get their order and just listen to it whenever they get that order because it's all saved anyway. I don't. That seems to me that's a major assumption you're making. I don't know if we have reason to believe it.
I'm not sure. I'm not sure I understand the assumption that I'm making. But,
well, I guess so we're watching the person in Pakistan.
Right.
The person in Pakistan talk to somebody in the U.S.
Right.
Under the current rule, they can listen to that call, determine if it's related to terrorism, get a FISA warrant if that person is related to terrorism. Say that again. Get a FISA warrant if the person in the U.S. is collecting if the conversation is about foreign.
They don't need a FISA warrant. They can just keep listening in.
No, they need a FISA warrant at that point.
No, as long as the surveillance is at least directed at the person overseas, they don't.
Well, but I thought the question is if somebody outside the U.S. is sharing information about an upcoming terrorist plot with somebody inside the U.S., presumably the United States government is going to want to listen in on anything they can possibly get about this person inside the United States. And for that, they obviously need a FISA warrant.
To broadly listen in on, to direct the surveillance
to get everything,
solely to the person in the United States.
To get everything except for that person's international calls.
Correct.
And why, if in fact they're watching an Al Qaeda suspect in Pakistan and he's talking to somebody in New Jersey about an upcoming terrorist plot, don't you think they would get a FISA order at that point? Why would they just say, well, maybe we'll get some scraps from his international calls, and hey, it's better than filling out all the paperwork. I mean, I think at that point that becomes an absolute priority one target, and that's what
that may be. But we agree on that, Orin, right? That if they want to begin new surveillance that's directed solely at the person in the United States, they have to go to the FISA court.
But your view is they need to make that call without knowing what the contents of that communication were between the person outside the U.S. and inside the U.S.
The question is whether any predicate showing has to be made at all before they listen to your foreign to domestic communications.
Right.
And your view appears to be, no, they should be able to freely listen to all of our international phone calls and read all of our international emails, as long as they can say that the surveillance is directed at least one person overseas.
No, my view is if they are actually watching a person of interest outside the U.S., and I happen to be communicating with this person in whatever country that is, yes, they should be able to read that email and determine, just as they can, we know they can from as soon as it crosses outside the U.S. We all agree that that's fine.
No,
my view is they should also...
we don't all think that's fine.
Well, it's legal under FISA. And
it's legal under FISA because Congress never sort of tied the knot, right? Finished the job that they said they were going to finish in 1978.
In this Senate report. The Senate report that defined all of American surveillance. The Senate report
at the time, it was nothing that would have given anyone a great deal of anxiety here, because most people were not engaged in numerous everyday communications with people overseas. Well, today we are, and I think, here I'm completely guessing, as you probably are too. I think most Americans, if you told them, should the government be able to freely listen in on all of your internet and phone call communications with people overseas, without any showing whatsoever, and without any congressional oversight, and without any judicial oversight, I think most people would say, whoa, yeah, if they can demonstrate that I'm doing something dangerous, sure, then listen in. But this goes way beyond that.
Well, but I think it goes back. I think some people would have that reaction. But a lot of people would say. A lot of people would say, how about a rule where you're allowed to start listening in, and if it's an irrelevant conversation, you have to stop. But if it's about a terrorist plot, then, yeah, you should listen in and then get a warrant on the U.S. person. Okay, I think a lot of people say that's a good idea.
Right. Even that would be much narrower than this bill. Even that. If you had to stop listening in unless there was some evidence of terrorist activity, that would be a great improvement.
Well, that's what I think the administration thinks the bill does.
That's what they're telling you. But there's nothing on the face of the bill that prevents that. And I hazard to say that this administration is not one I trust to take narrow readings of statutory language, particularly where there is, in this case, no legislative history defining that language.
But that goes to, and we'll move on to the Boumediene case in a second.
But two other things.
This goes to the question, again, a problem we always have. What are the minimization procedures really doing? What are the FISA court judges really doing? What are the relationships really like between the FISA court judges, the Justice Department attorneys? Are these procedures pretty strict, and are they taking them really seriously among the thousands of career? I mean, there are probably 10,000 people employed doing this every day, just a few miles from where you and I are. Are they like, go Dick Cheney, let's see what we can do, or are they following the rules that they have? And you know, my tendency is to think once you get to something that needs to be administered by a lot of people, the chances that it's going to be much more rule-bound becomes greater.
Because then the Dick Cheneys and David Andersons of the world are never able to persuade those people to go much further than they've gone in the past.
I think that's right.
Well, except that we have evidence that that's not the case, right? They got the NSA to violate the terms of the statute for 6 years.
Although now we're talking about submitting it to the FISA court.
Right, okay, so in fairness, and I want to get on to two other issues here that you're especially interested in and that I don't know enough about, even before we get to Boumediene. What this requires is a one-time submission to the FISA court, not of any particular surveillance, but of the procedures that you have in place to do the minimization that's required and the targeting or the directing, whatever directed at means, that the statute has in place. And you are right. It's conceivable that the FISA court would, in that, especially since it only gets one bite at the apple, at that one bite, they might be extremely strict with an administration and require all sorts of prophylactics that aren't laid out in the statute. Mm-hmm. I hope you're right. I can imagine that happening. I just wish that there were more protections in the statute itself to guarantee that that would happen.
Okay. Fair enough.
But let's talk quickly about two other aspects of this bill, I think. One, for some of our viewers might be interested. Let's say the statute does what I think it does, or even what you think it does, and that is generally allow the government, without making any showing at all in advance, to intercept, surveil, and maintain and interpret and listen in on or read all of our communications with people overseas, as long as they're directed at someone overseas. Putting aside whether that's a good, bad, best of all possible worlds from a statutory perspective, are there any Fourth Amendment problems at all with a system in which all of our international communications are surveilled?
There are a bunch of different legal arguments that suggest that no warrant would be required under those circumstances. So one is an argument that a couple circuit courts have passed on, which is that when the government is conducting foreign intelligence surveillance, no warrant is required. It's just a reasonableness rule. And that would apply even if it's entirely domestic. If it's, you and I are talking and the government's listening to our call.
Although in fairness, there was one other court, the D.C. Court of Appeals, that held that was only true if the person was an agent of a foreign, the domestic person was an agent of a foreign power.
Yeah, although it was dicta, wasn't it, I think?
No, not that holding. The dicta was whether the whole thing.
Right. Fair point. So that's one argument. You can sort of fold that into what today would be known as the special needs doctrine. If the government is monitoring for non-law enforcement reasons, there's just a reasonableness rule instead of a traditional law enforcement warrant rule. Another framework for a similar idea. You could also, I think, reasonably introduce the border search exception idea if it's an international call that.
Okay, so let me ask you this, because you're right. I think there are definitely arguments on both sides, and there are analogies that certainly would support the government's view that there's no Fourth Amendment problem with this. But let me ask you two questions. One, what do you think this Supreme Court, that is to say, Anthony Kennedy, aside to our viewers, Orin happens to have clerked for Justice Kennedy, but will not reveal any confidences that he learned there. What do you think this court would say on the question, and what do you, Orin Kerr, think on this question the answer should be?
What would the Supreme Court do if it came up to, if the certification came up in the statute?
Well, it's very hard to see how it would ever get to the court. I guess I'm asking this in a really abstract way, because we don't know the posture in which it would get to the court. But let's just say that there were a criminal proceeding, and it turns out that some of the evidence had been collected without any warrant whatsoever, just based on sort of a random intercept of people overseas that happened to reveal that the defendant here in the United States was plotting some crime with the person overseas.
First, I mean, it's not a realistic scenario because none of this stuff is ever going to make it into a criminal prosecution.
Right.
For a lot
of this will ever
reasons.
become public until there's another scandal, like the Church Committee scandals in the 70s. That's how these things really evolve.
I think today's preferred approach is the leak to the New York Times.
Orin, you're too young to remember this, but that's how a lot of things happened in the 70s, too.
Is that how it worked in the 70s, Marty?
Pentagon Papers.
That's true. It's true. I was a mere...
and there was back in the 70s, there was actually a modicum of congressional oversight.
Really?
It's just those were the days.
Those were the days. Back when President Nixon was following all the rules, and we didn't have to worry about these questions.
Right, exactly. Where you could be pretty sure there was wrongdoing going on, not like in the current administration.
Right. So on this Fourth Amendment question, I think the Supreme Court would not. There's no sort of obvious points that I think the Supreme Court would object to, if that's kind of the bottom line here. I think we're not really in Fourth Amendment danger here. We're really talking about statutory problems. There's a chance the Supreme Court could say, we're going to create new rules. We're going to say the Fourth Amendment applies all around the world to all sorts of people.
No. That applies to people in the United States when we're engaged in communications with people.
Or why not that it applies all around the world? We're in an international era, Marty.
I don't think there's 5 votes for that yet, although we'll get to that in a minute with Boumediene.
I think the bottom line is that the Supreme Court would not object to.
All right. Okay. So let's quickly move on to the other topic, which may be the biggest one of all in this statute, although, again, it's hard to tell because no one knows quite what the statute's doing, which is that in addition to giving this vast or modest new set of surveillance authority type of surveillance authority to the National Security Agency, Section 105 capital B of the statute also allows the government to, I don't know how to put that, require any person having access to these communications to provide the government with the communications. That is to say, it's a compelled access provision.
Right.
That lets the NSA go to, as far as I can tell, and you'll be able to tell me much more about this than I can figure out, go to a university, an employer, an ISP, a telecom provider, anyone who has stored or otherwise has access to phone calls or emails with persons overseas, and demand that they give the NSA access to their computers or wires or the like, and there's nothing much they can do about it. So this increases the NSA's capability of surveillance dramatically, significantly. What do you think?
Well, this is always an issue that comes up in surveillance rules. So you can give the government a power as an abstract matter, but then you've got to come up with another set of rules that allows them to implement that authority. Right. Typically being an order that says, okay, telephone company, you really have to go along with these requirements. You can't opt out. And what's different here is that this is a requirement of cooperation that's not specific to individual court orders. It's general to the certification under the statute. So that's different. I mean, there isn't a very specific one-on-one call being made. The big question I have about this is how many providers are really going to be affected by this? So it sounds to me, based on the James Risen book going back 2 years now, that it's a pretty specific group of U.S. switches that are really the hubs responsible for the traffic, the international traffic here. Not, Georgetown University or George Washington University or even another George University in the Washington, D.C. area.
George Mason.
George Mason. That's whatever your team is.
Or William and Mary, other great names.
Yes. And so I think that's probably affecting only a pretty small group. The AT&Ts of the world, not your local mom-and-pop ISP.
Because it just won't be necessary to go to the ISPs or the universities or the employer?
Exactly.
You'll be able to get everything from AT&T and Verizon. And
my understanding is, if you're in Algeria and you're calling somebody in Paris, the call's not being routed through, a local ISP. It's going through these major switches, and that's the people that are going to have to cooperate. And I don't know if there are any companies that are implicated that would have to cooperate that are going to object. There's a mechanism in the statute for objecting, but I just don't know how many.
But the objection would simply be that the NSA is acting unlawfully. There's no other.
Yeah, well,
you can't resist just because you don't want to help the government surveil international communications.
Right, and so whether that gets treated
protect the privacy of your employees or your students or anything like that.
Right, whether that gets treated, it's disturbing in some ways. It's it sounds like the writs of assistance that were being used in colonial times, where the colonial governor could, say, "Hey, I need you to help me execute this warrant," and everybody had to help out. But if it's only at a very limited set of providers in practice, which is at least my sense.
Those who have access to all of our communications overseas, yes.
Exactly. Right. There's only a few people, so maybe only a few people need to cooperate.
Well, I take it your reference to Algeria was the nice segue into Boumediene.
That's exactly right. Not a French name, an Algerian.
Okay, so what is this new Supreme Court case about? We're moving here from the Fourth Amendment and FISA to a couple of other constitutional provisions. The Fifth Amendment, the Due Process Clause of the Fifth Amendment, and the constitutional right to petition the courts for habeas corpus, which is often thought to be found in or implicit in the suspension clause of Article 1 or just in the postulates of constitutional design. What is this case about? This is a Guantanamo case. The court has agreed to hear it. The case will be argued almost certainly in December. The topside briefs by the Guantanamo detainees will be filed in the next couple of weeks. Then the government will file. What is this case about? Well, let me give a little bit of background about what I see as the large issues associated, the large legal issues associated with the government's detention program in the conflict with Al-Qaeda. And I think there are four. Three of them are substantive and one is procedural. One very important one is procedural. The two issues that have gotten the most attention perhaps are one, what treatment can be brought to bear on those we have detained? The whole torture question, which we're not going to get into in this blogging heads. I'm hoping we can get to it in our next one. But what legal limits are there on, for instance, the CIA's program of secret sites that Jane Mayer's recent New Yorker article so brilliantly described, and so shockingly described? That's number one. This case doesn't directly implicate that. The other that's gotten a lot of attention is military commissions trying certain detainees for violations of the laws of war. That was the subject of the Hamdan decision of 2 terms ago. And this case also does not really deal with that, which is a fairly minor, although very important aspect of the detention regime, because only a handful, if that, of the detainees will ever be tried in these military commissions. The vast majority of the detainees are simply in indefinite, incommunicado detention. And that's the third substantive question. And it's, to my mind, the most important question, perhaps, in the whole war on terror, and that is, who can the government detain? What is the category of people who can be detained militarily without putting them in the civilian criminal system until the hostilities end, which in this case could be indefinite or a great long time until Al-Qaeda fritters away or is no longer any sort of threat to the United States. So who can be detained? And then the procedural question, and the one that's up first in this new Supreme Court case, is what is the right of detainees to go into U.S. federal court to challenge their detention? And that's the habeas corpus claim. And it's this third and fourth issues that are before the court. Now, the main issue that everyone's focused on is the habeas question. Let me describe that very briefly. The question is whether they have a right to go into court. In the Military Commissions Act, and before that the Detainee Treatment Act, Congress set up a regime in which they sought to deny the detainees at Guantanamo the right to petition for habeas to a court, which is just a petition asking a court for release. Basically, I'm being detained unlawfully. I want to be released. Congress said you can't have that. Congress passed a statute saying we are getting rid of habeas corpus for these detainees. The Supreme Court had, in the Rasool case that Justice Kennedy was a potential, now a swing vote on because Justice O'Connor has left. In 2003, the court held that under the statute as it then existed, detainees did have the authority to go into court and seek habeas relief. Congress said, no, you don't. We're replacing that with a different system. The new system, the Pentagon will create these combatant status tribunal review boards to determine whether you are lawfully detained, CSRTs, CSRTs, or CSRTs. And first, you get your first bite at the apple in the Pentagon-based system, and they are to have some sort of a hearing that determines whether you are lawfully detained. And you can appeal from that, if they say you are lawfully detained, you can appeal from that to the U.S. Court of Appeals here in the District of Columbia. And there's a certain level of review. It's a little bit unclear under the statute, the extent to which the D.C. Circuit can fix any problems in the Pentagon system and grant relief.
So, Marty, what do you think is going to happen?
So the first question is...
What's the Supreme Court going to do?
So the first question is, the Supreme Court... There's three questions presented, I think, fairly in the case. The first one is, the lower court held that these detainees, because they're aliens detained outside the United States proper, they don't have any constitutional habeas rights at all. They never did. They didn't in 1789. They don't now. And so it doesn't matter that Congress switched their process of review. I think the court will hold 5-4 that these detainees do have constitutional habeas corpus rights. I think you probably agree with me on that, right?
I think it's this case is going to get a lot of attention. A lot of people are going to wonder what's going to happen, and that the parties could go up there and read from the phone book, and it wouldn't change the result. I think 8 of the 9 justices have already answered this question in so many terms. I think of the Boumediene case on this question as being the no, we really meant it case.
Yeah.
Because the Rasool decision was, to my mind, the majority opinion, a fairly unpersuasive statutory hook to avoid resting a case on constitutional grounds, and then Congress called the courts, called their bluff, and now we're back. And I think they do the same thing they did before. It's just 5-4 instead of 6-3. I absolutely agree. They're going to say that there's a constitutional right to habeas corpus because they're in Guantanamo Bay.
Right. That's right. Justice Kennedy will probably not reach the broader question of habeas rights for people in closer to traditional battlefields who are being detained in Bagram or Afghanistan. But I think he will say, if you read his opinions carefully, his view is that the Constitution does apply at Guantanamo to a certain extent, and that they have a constitutional right to habeas. Now, this doesn't mean that they win, even on the habeas question, because the next question is whether this alternative review process that Congress has provided for is an adequate substitute for habeas.
Right.
And whether this D.C. Circuit review gives them everything that the Constitution requires. And interestingly, the D.C. Circuit recently, in a separate case involving different detainees, recently put the government to quite a bit of burden that the government didn't want to be put to provide a lot more evidence of the grounds for why people have been detained, and give the reviewing court, the Court of Appeals, greater power to review all of the evidence that the government has, or most of it, to determine whether the detention was lawful. And so
what do you think the court's going to do on the?
I think that's the hard question. I think, and I think there might be a middle ground that the court might take. I think the court might think that as to future detainees, people who are detained from this date forward, they can trust the D.C. Court of Appeals to do the right thing, to have sufficient oversight over the Pentagon's detention regime, that it might be constitutionally sufficient, or at the very least the court would tweak it a little bit, right? They would insist that the D.C. Circuit have the power, for instance, to actually order you released, and to not have your detention be based on coerced evidence, such as evidence from torture. So the court might say it's close now, and with a couple of tweaks, important tweaks, it might be sufficient. But as to these folks have been at Guantanamo for going on 6 years now. I know more about the Boumediene. There's 2 cases. I know more about the Boumediene petitioners. There's 6 Algerians who are 5 of them are Bosnian citizens. The other is a Bosnian resident, who were handed off by, these are not al-Qaeda terrorists, proven al-Qaeda terrorists captured in Pakistan or Afghanistan. These are Bosnian citizens who the Bosnian Supreme Court held there was no evidence that they had engaged in any criminal wrongdoing, ordered them released, and upon their release, the Bosnian police handed them over to the United States, which transported them to Guantanamo. So these folks are sort of a far cry from, well, I don't know what the evidence will show, but they're not your prototypical run-of-the-mill Al-Qaeda terrorists in Pakistan. It's a very different sort of thing. And they've been languishing at Guantanamo.
You just made all the Bosnians in the Blogging Heads audience very happy.
Why is that? Because I'm going to protect them from being swept off the street and sent to Guantanamo?
The Bosnian Supreme Court spoke.
The Bosnian Supreme Court.
I should say, I think...
No, but my point was simply going to be, I'm not sure that this new review process, which could take years to resolve their claims, the court might well say that as to these detainees and others like them at Guantanamo, it's too late in the day for this new-fangled, drawn-out new review process. They should have their day in court right away so we can finally determine whether they've been lawfully held for 6 years. Whatever the rule should be going forward, I think the court's going to be sympathetic to the claims of these petitioners.
Yeah, I think you're pretty much right. I think it's going to be a bad day for Paul Clement or whoever has to argue this case. The government's going to get slammed in this case. It's going to be ugly. For a bunch of different reasons. Among them, you look at the cases on what adequate and alternative remedies mean. They basically mean the equivalent of a traditional habeas proceeding. And obviously the proceedings below are not traditional habeas proceedings or anything that really look like them. And I think it's just going to be ugly. It's going to be really ugly. And what this brings up two things for me. I actually don't think there's a lot of drama. I mean, it'll be really interesting. Hopefully they'll release the audio of this case. Because then we'll be able to listen in and just hear the blows and the oohs and ahs of the audience. But
you're setting up our viewers for disappointment. It's not quite that dramatic.
Well, yeah, for the geeks that are this far into this video, they're probably the kind of people that find that dramatic. But to my mind, it really sets up two questions. One, is the Bush administration going to shut down Guantanamo Bay in response to this? Because what's odd about this entire picture is that the only reason that these detainees have rights is that they were brought to Guantanamo Bay. The administration brought them to Guantanamo Bay on the assumption that they wouldn't have rights, because it was not in the U.S. So there's sort of a trick here that the Supreme Court says in 2004, no, it is part of the U.S. on statutory grounds. Now, this time around, they'll say it's on constitutional grounds. And that just tells the administration, don't bring anyone to Guantanamo Bay.
Right.
So then they shut down Guantanamo Bay. They take everybody somewhere else. This litigation is still ongoing the last day of the Bush administration. And whoever is the new president says, oops, we messed up, turns it around, and tries to settle this and put this away.
But
I actually think this case is not... It's going to be fun to watch, but I don't think it's going to be terribly important in terms of the long-term picture of what happens with this issue. I mean, it'll be an important precedent, but I think it's going to be a precedent that's about this one place, Cuba, and it's not going to extend beyond that.
Right. Well, we should explain to our viewers. I mean, that there would be very little question here that if these detainees were either American citizens or residents, or were aliens being detained here in the United States, there would be little question that they would have habeas corpus rights. The only reason that there's an issue at all is because in flying them halfway around the globe, the government turned left at Florida rather than right and decided to detain them at this U.S. facility in Cuba rather than Charleston.
That's a somewhat stacked expression. You could flip it. You could say, there's absolutely no reason why any of these people would have any rights except for the fact that the Bush administration brought them close to the United States.
Well, it would raise the harder question, which is, what if they are being detained at some other facility in a place where a foreign government did have sovereign rights and sovereign law applied, such as at one of these CIA black sites or at Bagram, or at a place where the United States is an occupying power. Very complex questions might be raised at other locales around the world.
What's the answer?
In terms of constitutional habeas rights?
Yeah. I don't think the Supreme Court would recognize them outside of Guantanamo Bay.
I can guarantee you this: if they closed Guantanamo and moved these hundreds of detainees to a site back on the other side of the globe, I'll bet that Justice Kennedy would be fairly inclined to recognize habeas rights.
I think what they would do is say, as soon as you're in the U.S., you can't lose them by virtue of being forcibly removed from the U.S.
And Guantanamo was effectively the U.S.
And Guantanamo was the U.S. And actually, let's tie this together.
The hard question, Orin, is when you get away from the exigencies of battlefield detention proper, right? The detention that's happening sort of on the ground with the bullets flying,
right,
and to long-term detention under the complete control of the United States.
As in the Eisentrager case.
Anywhere. Right. Whether the U.S., whether those folks should have the right to go into court. And I think right now there are actually 5 votes to say yes on that, although if you read Justice Kennedy's opinions, I think it would be somewhat of a sliding scale. He would say that the habeas and due process rights you're entitled to will depend on the equities of the situation, on the other governments that are involved, on the law that might apply to them otherwise, and the like. He takes a very contextual view.
Let's tie this back to the, because it seems to me actually we're having exactly the same conversation on Boumediene that we had on FISA.
Except that I haven't gotten to the secret bombshell that might happen in Boumediene.
Secret bombshell? So
the secret bombshell
Marty, what's the secret bomb? You've been hiding the secret bombshell? We've been doing it for an hour.
Most everyone thinks that Boumediene, and it is largely about this question of habeas corpus rights and whether the D.C. Circuit Review is an adequate substitute. But one of the petitions, the Boumediene petition, has a second question presented, and it urges the court not only to grant them habeas rights, but to actually determine what the standards are for who can be detained and who can't. The merits question, and to my mind, the most important central question of the entire rigmarole. Now, I think you will agree with me that the odds are that the court, even if they rule in the petitioner's favor on the habeas question, will probably not reach the question of what the standards should be for who can be detained. Can you detain these Bosnians who were picked up off the street in Bosnia? And on what evidence? What's the evidentiary showing, both the substantive standard and the evidentiary showing and the procedural protections that need to be in place in order to detain someone? But if Justice Kennedy...
Have the lower courts even passed on this question?
Not really.
So the Supreme Court's
the
not going to try
irony
to
is this is both the most important question in the whole...
They're not going to try. Do you think they're going to say, well, no court has ever even touched on this, let's just start? I mean, they're going to wait until...
Well, it's sort of like Hamdi, though, right? Except as to aliens, right? So it's a big kettle of fish. But it's not as though the court hasn't said anything about about who can be detained and who can't.
Okay.
It did provide certain guidelines as to U.S. citizens and when they could be detained in the Hamdi case.
I see. So you think they might just give the same Hamdi-like balancing framework?
I think because what Justice Kennedy and the rest of the 5-justice majority might conclude is that giving these folks the right to habeas is only, enough already. Right?
In so doing, it would probably settle the Almari question.
Right, exactly. So he might be at the point where he wants to say, enough. Every time I take a half step, the administration takes 2 steps back and only goes, at best up to where I said, and then starts pushing back in every way imaginable. And it's time for this to end.
Well, I mean,
or at least to have trials based on a standard that the Supreme Court has already approved.
What's really interesting
as to who can be detained and who can't.
What's really interesting about this is that there's a year and a half left of the Bush administration.
Right.
And so let's assume that whoever is the next president looks at all of these cases and says, is there an exit door? Because I don't want to get bogged down in these cases.
Right.
Maybe not Giuliani if he's elected, but most of the other ones would seem to want to just get out of this. And to what extent is that going to influence what...
Governor Romney wants to double down on Guantanamo. He wants to find more people, more Guantanamos, more detainees.
Well,
he said the more Guantanamo. What did he say? Two Guantanamos. The more the merrier.
Well, if Mitt Romney is elected president, I will withdraw my statement, Marty. But assuming Mitt Romney is not elected president, a lot of the candidates I think would just want to get out of this. And the question is, how does that change what the justices do? And how does that change how we approach these questions? Because we're obviously knee-deep into these questions, and we're really into, well, what about this part? What about that part? Assuming that there's this sort of constant flow of cases and this constant trend, which has been the case since 2001 because we've had the administration which has been strikingly consistent, some would say stubborn, throughout the entire process. But that's going to change.
Right.
And I wonder how that impacts what the Supreme Court does, in that so far they've been pretty careful. Everything's been on statutory grounds, whether it's persuasive or not. They've been sort of cautious, and then do they sort of become bolder at the end when the rules are really going to impact a different administration?
That's a good point. And another thing to think about is by the time the opinions start being circulated in this case, the court will probably know who the two candidates are for president. And
which is not to suggest, we should make clear that it's not like the justices sit around and like, oh, well, look who the nominees are. Maybe we'll do this.
They're oblivious to those sorts of considerations.
They're making legal decisions on they're not following the headlines.
Purely
this is law professor speculation. We should add.
Hey, so Orin, we were going to go on to talk about what's the difference between law bloggers and non-law bloggers, but the red light. I've been told the red light is on.
Yeah, let me add a concluding thought, if we can.
All right.
Then. It seems to me that the topics we talked about in this exciting episodes of Blogging Heads were really the same thing. So one was surveillance, the other was detention. But in both settings, we're dealing with a traditional line. So there was the outside the U.S. no rights, inside the U.S. rights, sort of the traditional framework. And what we're dealing with in both the surveillance context and in the Boumediene case is, what do you do when you've got something that's sort of partly U.S., partly non-U.S.?
It implicates U.S. persons and non-U.S. persons. There's
sort of a U.S. interest there. I mean,
geography starts breaking down.
Geography, is it where the monitoring occurs? What's the key variable here? And in both cases, the legal issues that we're dealing with are trying to deal with the category of, to what extent does the place matter? All these disputes are about the place of the war on terror, and to what extent should the rules depend
place of the war on terror
where the surveillance or detention is occurring,
and the extent to which, at least in Boumediene, the extent to which aliens are protected by our legal regime. Not so much in FISA, but
they're not. Well, it's only aliens protected that are then brought to the Guantanamo Bay Naval Base.
So far, that's right.
Right.
That's right.
But so it's placed in the sense of they're detained in Guantanamo Bay. In the FISA legislation, it's placed in the sense of it's monitoring inside the U.S.
Right.
We're both dealing with that same problem. It just manifesting itself in two different places.
And this occurs in many of the controversies in the conflict against Al Qaeda because of the nature of the conflict.
So have we settled all of it now?
I think we have,
Good.
and I think the justices will be very pleased that they have. We've done their homework.
I should hope they supplement oral argument with watching Blogging Heads.
And maybe if we do this again, we can talk about why we blog and who our audiences are, because I think it's a little bit different than the audiences for most of those who appear on Blogging Heads.
Sounds good.
Anyway, Orin, it's been a pleasure.
It has been a pleasure, Marty. I'll probably end up talking to you probably tomorrow. So until then, I'll see you offline.
All right. Thanks, Orin.
Great. Bye.